what the landlord has to do is give a notice saying, this is how much you owe in rents. And then the landlord has to give you 7 days to pay it. And if you can pay the whole thing and offer it during that 7 days, the landlord has to take it. Once that 7 days is over, all bets are off and the landlord can choose what to do. So practically speaking, you might not be able to come up with $10,000 if you're that far behind, but there's no kind of legal cutoff there.
And could they do it if you were just 1 month behind?
They could do that if you paid everything except for $5 of your rent. They could give you a notice quit for $5. And if you didn't pay that and it went to court, you would probably get evicted for that.
Welcome to the East Anchorage Book Club. I'm your host, Andrew Gray. The purpose of this podcast is to tell the stories of Alaskans of interest and importance. Today's episode is a little bit different. Last night, I held a constituent town hall on Zoom regarding renters' rights. According to Alaska Economic Trends magazine, the average rent in Anchorage went up by 14.2% from 2021 to 2022, and then rose an additional 5% on top of that this year. The average median rent in Anchorage is $1,532 per month. I have heard from constituents their fear that they may lose their apartments due to inability to pay. In response to their concerns, I invited today's guest, fair housing expert, attorney Dan Coons, to speak. Dan has been working at Alaska Legal Services since 2010 and specializes in cases involving illegal housing discrimination, eviction prevention, as well as a broad range of other civil legal issues. Although I geared this event toward my constituents, and you will hear folks unmute and ask their own questions, I actually needed this town hall for me. I was not aware just how free Alaska landlords are when their tenants are on a month-to-month lease to increase that rent by any amount as frequently as they might like for as long as they might like. At the end of this episode, we will offer some resources to help folks struggling with rent or facing eviction, and links to those resources can be found in our show notes. Finally, today is Veterans Day. From one veteran to another, happy Veterans Day and thank you for your service. If you are a veteran who is at risk of homelessness, please call the National Call Center for Homeless Veterans, 877-424-3838. Someone is there to help you 24/7. Now for today's episode. Dan Coons, welcome to the podcast.
Thank you. Thank you for having me. I appreciate the invitation, and thanks to you and your staff for setting this up. I always like talking about housing rights, so I appreciate it. So I'm an attorney at Alaska Legal Services Corporation. My official title is I'm our Fair Housing Project Director, which I guess I'll explain the meaning of that in a minute. But I moved back up to Alaska from Arizona. I lived here when I was a kid and kind of lived in the Midtown area and always wanted to come back. And so I did and got a job, working on a nonprofit law firm. And I've been here ever since. When I started, I was working on eviction prevention and foreclosure prevention work. So a lot of housing related work. But then in 2015, we received a grant from the Department of Housing and Urban Development, HUD, for our Fair Housing Project. And what that specifically refers to is preventing illegal housing discrimination and ensuring equal housing opportunity. That's what I do now. I work as part of that project, and as well as continue to deal with the more kind of straight landlord-tenant type issues. So that's me. I can talk about Alaska Legal Services a little bit, just so people are a little more familiar.
Yeah, tell us, what is Alaska Legal Services?
Yeah, we're a nonprofit law firm. We've been around since the late 1960s. We got offices statewide. We provide free civil legal services for people, no criminal law work. And most of our services, I'd say most, are income restricted. So we can assist people as long as your income is below a certain level. So there's a short application process to figure that out, as well as figure out if it's the kind of case we can help with. That's not true of all our services. And in fact, it's not true of our fair housing services. If someone is facing a discriminatory issue in their housing, We can assist them regardless of their income level or any assets they might have. And beyond the housing work, we help with family law issues. We help people with public benefits. Recently, we've been helping tons of people with SNAP issues, food stamp benefits, because that's a big issue now, as well as native law issues, people who are facing debt collection issues, things like that, a broad range of civil legal issues.
Have you had more cases in the past few years related to housing?
I would say it definitely slowed down quite a lot during the pandemic due to both the moratoriums that existed that kind of stopped evictions for most people for a while, as well as then some of the financial rental assistance that was available for a period for both rental assistance for tenants, but also for homeowners, there was assistance as well. But yeah, it's definitely gotten back, as far as I can tell, to what it was before, if not more, frankly. Partly our intake system has changed a little bit, so I see more cases now than I would have pre-pandemic, but I think it's increased a little bit at least.
What do you think are the things that renters today don't know that they should know? Are there any big, just right out the gate, any particular issues that you wish renters had a better understanding of?
Sure. And I guess I should probably give my attorney disclaimer here first, that don't take this as legal advice, or this isn't creating a lawyer-client relationship. But yeah, in terms of giving information about that, maybe it's just getting back to basics about how the eviction process works. I think a lot of people, unless they've encountered it and dealt with it, they don't even quite understand the process, which is that your landlord has to give you a written notice saying what the basis for ending your lease is, for evicting you because you violated your lease or you didn't pay your rent, or maybe just you have a month-to-month tenancy and that's just the landlord's just choosing not to renew it for no reason. But in any of those cases, you'd have to get a written notice. There might be things to do to fix that problem. If you're behind on your rent, you get this notice, it tells you how much you owe, and then you have the opportunity to pay it within 7 days. That's like the first essential step. But then the second essential step is that the landlord has to take you to court and get a court order if they want to evict you. You can't, it's illegal to go around to avoid the judicial procedure. So it's illegal to lock someone out of their home without a court order. The police, generally, law enforcement isn't going to come and make people leave their home unless they get a court order. If someone is threatened with eviction, there's a way they can assert their rights, which is through the court process. There'll be a hearing in front of a judge, and they can give their side of the story and give a defense and hopefully avoid eviction. They can take advantage of the eviction diversion program that now exists and maybe work something out and avoid an eviction. Even if they do end up having to leave their home, maybe they can not get an eviction on their record, which can have some long-term effects on someone. If your name is in the court system and publicly viewable and you've been evicted, a landlord might be less willing to rent to you in the future. So I think that's important to know. I think it's also important to know that it goes pretty quick, right? These notice periods are pretty short. The time in Anchorage between a landlord filing an eviction case and having a hearing in front of a judge is a week, typically, maybe a bit more, maybe within 1 or 2 weeks. And then if you get evicted, typically it's only 48 hours until that kind of eviction takes effect. And the troopers at that point, with an order from a judge, can come and tell you you need to leave your home. So it can be a very quick process. It's designed to be summary and fast. So that's certainly one thing. And I'm happy to talk about that in more detail. The other thing, I think a lot of people aren't aware of are these fair housing laws that also protect from discrimination. I think most people would think maybe the obvious, they would say, oh, it's probably illegal to discriminate against someone based on their race or their religion in housing. I think, yeah, people would just feel that. But there are a lot of other kind of protected classes. Basically, under the law, you can't be discriminated against because of your race or color, or your religion, your national origin. So that can be related to language issues if English isn't your first language or you don't speak English at all. You can't be discriminated against based on your gender, which includes the fact that you can't be discriminated against based on sexual orientation or gender identity. You probably can't be discriminated against based on being a survivor of domestic violence. Sexual harassment is illegal as gender discrimination as well. So there's a whole group of things captured under gender discrimination. And then finally, you can't be discriminated against based on disability or familial status, which means having minor children in the home, having kids.
Yeah, I was going to ask that. So you cannot be discriminated against because you have children.
No.
You can't say no kids.
No, not unless there's certain kinds of senior housing that are exempted from that. But as a general rule, yes, since like the late 1980s, that's when they added that to the law.
If it's okay, I want to go back and ask two questions about eviction that you were talking about. So the first question is, if you've signed a 12-month lease, can you be asked to break the lease for no cause? Can they say that they've decided that they want to do something else with the property, that they want to, regardless, but it has nothing to do with you as a tenant, but they've decided to do something else with the property and your lease is not complete. Do you have a right to stay for the full year?
Yes. Essentially, that ability to terminate someone's lease with a 30-day notice for no cause, that's only at the end of a lease term or once you've automatically turned into a month-to-month lease, which is what happens at the end of a lease term. And so a judge would not typically, if you could show you have that lease term, you'd be in a pretty good position. One kind of thing I've seen come up occasionally is that sometimes the language in the lease says both things at once. It'll say, this is for a year. And then later on, it'll say, but I can terminate it based on a 30-day notice. And I think that gets a little more complicated in terms of analyzing that. But if it's clear that it's a year lease, no, that termination, eviction has to be for cause.
And then once you've passed the year mark, let's say you did a 12-month lease, but now you're at month 15, then at any point, they can give you a 30-day notice. On the 28th of the month, they can give you a 30-day notice for no cause and say that they're going to do something else with the property and that they need you to leave. If they did it on February 28th, then you'd have until March 28th and then they would prorate your rent. What are the parameters?
Sure. Well, the precise language of the statute changes it a little bit. What is it? 290, I think it is. I always got to go back to it because it says and this applies to both the landlord, but also the tenant. When the tenant's like, I don't want to live here anymore, I'm ready to move out. So this is a right that kind of is on both sides. But the landlord or the tenant may terminate a month-to-month tenancy by a written notice given to the other at least 30 days before the rental due date specified in the notice. So what that would mean, and the courts interpret it this way, is say if I was a landlord and I gave my tenant a notice on March 15th, I couldn't then say, you need to be out on April 15th. I'd have to say,
April 30th.
You need to be out on, because the 1st is the typical rent due date.
So, and I guess the next question would be regard to for cause. And what are the reasons why you can be evicted for cause? Like exactly. Because you hear stories of my kids were too noisy. The other neighbor was complaining. things like that. Can you be like, what are the specific for cause reasons that you could be asked to leave?
Sure. Well, I don't know if it can be very narrowly defined because it is broadly violations of the lease. So it can be all sorts of behaviors that potentially violate the lease. In part, I two notes about that is it needs to be specified in the notice. It can't just say you violated your lease, you need to get out. In part because most lease violations are curable. The notice should say, this is how you violated your lease. If you fix this problem within the next 10 days, you can stay. You won't be evicted. If the landlord chooses to go forth and file an eviction, they're going to have to prove those kind of violations, right? That's going to be their kind of prima facie case, to put in legalese, right? That if they say there's a noise problem, they're going to have to put on evidence that there, in fact, was a noise problem to show that they have some basis for the eviction. Yeah, I don't know if I wish I could define it a little more narrowly and what kinds of things can potentially be lease violations, but it honestly can be pretty broad.
And I assume the most common reason would be that you're behind on your rent. How far can you get behind on your rent and have it still be curable? Or is there a point of no return?
No, there's not. It doesn't matter because what the landlord has to do is give a notice saying, this is how much you owe in rent. And it has to specifically be rent. It can't be like rent plus a bunch of other fees or fines you owe. And the notice has to specifically say what that amount is. And then the landlord has to give you 7 days to pay it. And if you can pay the whole thing and offer it during that 7 days, the landlord has to take it. Once that 7 days is over, all bets are off and the landlord can choose what to do. So practically speaking, you might not be able to come up with $10,000 if you're that far behind, but there's no kind of legal cutoff there.
And could they do it if you were just 1 month behind? So if you're 1 month behind, they can give you the notice and you have 7 days to come up with just that smaller amount of money.
They could do that if you paid everything except for $5 of your rent. They could give you a notice quit for $5. And if you didn't pay that and it went to court, you would probably get evicted for that.
So I want to change topics. We can come back to eviction. I'm going to leave time for questions. And if people have questions, we can come back to that. But I wanted to now go to the topic of rent because the last few years, we've seen historic raises to rents in Anchorage and particularly in my district. And I wonder what the parameters are around raising rent. How much can rent be raised? How often can it be raised? When can it be raised?
Sure. Really, under Alaska law, the only kind of major parameter on that is the lease term. Typically, if you had a year-long lease, that lease amount would be set in the terms of the lease, and during that year, it could not change. Like that other situation, you find places where people will then put in the lease, I can change the lease amount. And that gets a bit more fuzzy and complicated. But essentially, if it's a month-to-month lease, which is a situation that so many people are in, the landlord would have to give at least 30 days notice of the rent increase, because essentially the way a month-to-month lease is conceptualized, each month is like a new lease that's just repeating over and over again. So you have to at least give this notice. But beyond that, there aren't any kinds of restrictions on how much the landlord can raise the rent or how often or things like that, unless you could tie it back to a specific kind of retaliation about, say the tenant was making complaints about some kind of maintenance issue, and you could somehow tie the rent being raised to that complaint so that it could clearly be seen to be retaliatory. That would be illegal. Likewise, if you could somehow show it was discriminatory and that certain groups of people were being treated differently than other groups of people, you could potentially do something about it. But beyond that, I'm not aware of any kind of restrictions.
So I'll just give you a hypothetical to see if I understand it. So let's say you had a leak in your living room and you called the landlord and you said you needed the leak fixed, and they came to fix the leak, but it continued to leak, and you basically just were having to stay on it, and they had to send somebody several times, and you anticipate that it was, in the end, it was eventually fixed, but it may have cost a lot of money. And then all of a sudden, the landlord gives you a notice that your rent is going up by $200 a month, and you suspect that it's because you were adamant about getting the leak completely fixed.
Sure. So I think, and this kind of gets into, I don't know, legal strategy or just like how things work in the real world with the court. I think that's exactly right. If the rent was raised, you got a notice immediately after you made these requests, and the landlord had to spend this money, that creates a pretty strong inference that the two things were tied together. And it really does depend on like how close in time it is. Maybe from the tenant's point of view, and as a piece of evidence, ideally the landlord says something like, I'm tired of you complaining. So
right, you made me replace the roof.
Yeah, exactly. But then the question is, how is that all going to work out? Landlord says, I want you to pay more rent. I say, no, I'm going to pay what I was paying because I think what you're doing is retaliatory. You're going to get taken to court for not paying that new amount of rent, right? You're for a non-payment of rent notice. And then you're going to have to convince the judge. You're going to be standing there in front of the judge saying, this is my evidence that this was a retaliatory act, and they shouldn't be allowed to raise the rent because it violates the Landlord-Tenant Act and the sort of anti-retaliation statute. And you hope the judge buys it, because if the judge doesn't buy it, you're going to get evicted. So
I have a question to go back. Let's say you suspect that they're actually raising the rent because they want you to leave. It's a pretty big jump in rent and you can't pay it, and you're going to have to leave. Do you have and I guess it's probably too much work, but if you leave and then they have trouble finding someone to fill it at the rent that they said it was going to be and they lowered it back down, is that a case? Or is that just too much work?
Yeah, no, I don't think it would be. Not only not, it would be too much work probably, but I don't even know if it would be. I don't know what the cause of action would be, like what the basis for that case would be. It would just be like, I thought the market was going one way and now it's going the other way, and that's what happened. That's probably how a judge would perceive of it.
Okay, last question, because I want to make sure I get to everything on the flyer before we open it for questions. But as far as deposits go, and I'll just share that I was a renter until I was 45 years old. So I've owned my half of a duplex for really 3.5 years, not that long. But prior to that, I was always a renter, and I actually did have a landlord keep my deposit. I felt that I was a very clean and tidy tenant. And they said that they had to do a deep clean of the oven. They said they were going to have to repaint the walls. They said they were going to have to replace the carpet. And I can assure you that I had a clean oven. I did not mark up the walls. And there was just normal foot traffic on the carpet. It was nothing. There were no deep stains. And they kept my entire deposit, and I had no way. I didn't know what my recourse was.
Yeah. I think it is really, the option is, if a landlord keeps a tenant's security deposit, is to sue the landlord in small claims court. And obviously, for a variety of reasons, that's not really a great option for a lot of people. A couple things. What the Landlord-Tenant Act requires is that the landlord has to give the security deposit back, or have a specific kind of accounting of what they spent it on within, in almost every situation, 30 days of the move out. And if the landlord doesn't do that, or then if you sue the landlord to get the security deposit back, you could potentially get double the amount you're owed back. But I think it, more than anything, these are all proof issues that when it ends up in court, who has the evidence of what kind of damages there were and what they cost and things like that. Certainly, we always advise people when they're moving out to take pictures, videos, if there's people who are witnesses to the move out, keep in touch with them and things like that, so that you have that kind of evidence. But yeah, really the only option to get it back is to go to court.
How much does it, let's say you're lower income, you needed that security deposit so that you could put your security deposit on the next place. Mm-hmm. How much does it cost to go to small claims court? How long does that process take?
It is relatively inexpensive. I don't know exactly right now, but the filing fee is probably around $70 or $80. Now, you can serve someone and get the process started through certified mail, which is $5, whereas if you got to hire a processor, that's $60 or something. And you can get a waiver for that fee. Actually, there's a form you can use, a court form. That's a financial affidavit where you say, because of your limited income, you shouldn't have to pay the filing fee. So there is a way around that. In terms of time, it can be pretty quick as far as the court system is concerned, maybe a couple months or something like that. There's all sorts of complexities and difficulties I could go on to add. Maybe I'll briefly try to. The defendant in a small claims case can choose to take that case out of small claims and bring it into the district court instead, which means that the whole case is going to follow a different set of rules. There's going to be discovery. There's going to be all these pretrial deadlines. It's going to take way longer. So that's a potential risk of filing a small claims case. That'll happen. In addition, you're allowed to have an attorney in small claims. And one thing about the Alaska landlord-tenant law is that the winning side in any kind of case related to the Landlord-Tenant Act, even if it's just a small claims case, not an eviction case, the winning side gets their attorney's fees paid by the losing side. So there's always a risk that if you're going into court to sue your landlord or vice versa, if you lose, you could end up on the hook for attorney's fees. So that can be a problem.
I want to open this up to questions, but before that, since I am a legislator and I'm curious about your opinion about Alaska's landlord-tenant laws compared to other states, and do you believe there's room for improvement?
I should be careful how I say this because there's all these very strict limitations on our ability to comment on those kinds of things as a legal services corporation entity. And unfortunately, I actually, this is the only place I practice this kind of law too. Mm-hmm. So I really don't have a basis of comparison, even though I lived in Arizona and was briefly a lawyer there. I did immigration down there. So my knowledge of even that is very limited. So I'm not really sure.
Maybe you know someone who might be able to answer that question, and I can refer to that person to get that question answered.
Yeah.
Because from what I've heard so far, we seem a little bit tilted towards the landlord. I just think that trying to get your deposit back, if you don't have if hiring a lawyer, an attorney would be a burden. And it's like, how are you going to afford to pay for an attorney when you're just trying to get maybe $1,000 back? And it just seems like the risk is too high to get $1,000 back.
One thing I would add to that too is just because of our resources are so limited, to the degree we assist people, we typically assist people avoid eviction. we don't assist people with getting their security deposit back, small claims, things like that. We just don't have the resources. So even as a free legal services provider, we're not a resource that people can use other than just to get some advice about that.
It also seems that being able to raise people's rents however much you want, however often you want, once it's a month to month, that I'm just going to guess that there are probably states that have some parameters around that you can't just raise the rent however much you want, however often you want. And it seems like there could be some common sense parameters to how much a landlord can raise rent.
I mean, certainly, yeah, we've certainly had clients who have come to us who are dealing with losing their housing because the rent's being raised and they can't keep up with it. And there's really no legal tool that we can use to help them.
Thank you. I would like now to offer if anyone would like to unmute and ask a question, now is the time. And I think Elizabeth had unmuted, so I know she has a question, and I saw Kathleen unmute as well. So I think we've got some questions coming.
I was wondering why they're allowed to require two previous landlords, and then normally they require about a full month's rent for a deposit. Why they're allowed to make their own rules and require so much of a person, even someone who's 18.
Well, I mean, from my perspective, there just aren't any laws governing those kinds of things. It's really in the landlord's power to frame their rental applications the way they want regarding those kinds of things. What the income level needs to be or what kind of references are needed. I'd say the one big exception to that is if there's anything that's discriminatory, where if one group of people is being treated differently in terms of what kinds of questions are being asked or what kind of requirements are being put on them. Just to simplify, to say, if you're requiring 3 reference from all Black applicants and 1 reference from all white applicants, that would be highly illegal, for example. Now, how you would find that out maybe is a little more complicated. One of the interesting things we do is we do what's called fair housing testing, which is where we have part-time employees who are essentially kind of secret shoppers, and we send them out in pairs to see if they're treated differently when they apply for housing. And the pairs where there's one Alaska Native applicant, one white applicant, one person with a disability, one person without a disability, and we see if they're treated differently. And that can be a way of discovering discrimination that might not be obvious on the surface to the one person who's applying, and getting just one set of questions and requirements.
Okay, so has anybody tried to put limitations on these things for the landlords or for the renters? Because from the renter side of it, it's very hard to find a place to rent. It's just getting harder and harder.
Yeah, all I can say is I can't even remember when it was, maybe 2014 or something like that was the last time Alaska's Landlord-Tenant Act has been amended. And we were invited to comment on that, which we can do if we get a specific invitation to comment on a specific piece of legislation, we can do that. I don't recall that even one of the issues that was tied up. Some parts of it are now part of the Landlord-Tenant Act. Some of them got dropped, but I don't even recall it addressing any of those kinds of issues.
Is that good, Elizabeth? I'm going to let Kathleen go, or Kathleen or Tanya.
Okay, I have a question concerning reasonable accommodations for a handicapped renter. My friend has been a long-term renter in this one apartment building, and she became, not suddenly, but over time, having a need for certain handicapped accommodations, specifically handicap bars in the bathroom area, and also some modification of the entrance into her apartment. She has steps and just only 2, but it's very difficult for her to get inside because there are no grip bars or side bars or anything on the building that she could hang on to get in. So she has repeatedly asked the landlord about some accommodations as such to make it easier for her to continue to live in her apartment. She is currently on a list for another housing unit that is handicapped accessible. But in the meantime, she's having a lot of trouble. What are her options for this with a landlord that is not really complying?
Sure. Thanks for asking about that. That's a huge part of what we do is assist people with reasonable accommodations, people with disabilities. And that's true kind of nationwide. Almost the majority of like fair housing enforcement that goes on relates to reasonable accommodations and disability discrimination. So it's going to depend on various things. First, there's the distinction between reasonable modification and reasonable accommodation. Reasonable accommodations are aimed more at a change to a landlord's policies and practices and rules such that a person can enjoy their housing with their disability the same as people without disabilities. For, a couple of examples, having an assistance animal and a no pet apartment complex, having a reserved parking space near your unit if you have a mobility disability, even though the apartment complex doesn't normally have assigned reserved parking spaces. Reasonable modifications or structural changes, so the grab bar, ramps, those kinds of things. In private housing, it is the tenant's responsibility to pay for those. So when a tenant is making a reasonable modification request, say to install a ramp, they're asking for permission to add that ramp, but they're responsible for putting in that ramp, or at least the cost of doing that. And in those situations, I know it's been a while, I don't know if it's true anymore, but I think Access Alaska would help people with those kind of payments and things like that. Maybe if someone were under Medicaid, maybe that could be a resource for paying for that modification if they were low income. The one big kind of exception to that is if the housing is federally subsidized in any way, then it becomes the landlord's responsibility to actually install and pay for that modification, because it's a different set of laws that apply. It's called Section 504 of the Rehabilitation Act of 1973, which kind of basically created disability rights and disability protections across all government programs. So that would be different if this person is in a federally subsidized housing.
What if they gave you an option saying, if you pay for it, I will install it, and then they haven't, and it's been like 4 months?
Oh, they're like dragging their feet?
Yeah.
Kind of thing. Yeah, I think there's kind of one of the basic rules about reasonable accommodations or modifications is not giving an answer is essentially the same as a denial. And I think that's true if it's, yes, we'll do this, but then nothing happens. I think that's, potentially an issue. And I think there's at least the argument that violates the Fair Housing Act by dragging things out like that. Because in the meantime, she's having to deal with not having that modification.
Yes. Yeah.
So if you bought the item and they're saying they will do it, but don't get back to you necessarily to give you the exact date, what would somebody do after that?
I think if they were a client of ours, we might write some letter pushing them to do it and saying that if they didn't do it, we'd file a fair housing complaint. The Department of Housing and Urban Development has a whole unit called the Fair Housing Equal Opportunity Unit that is dedicated to fair housing enforcement. And you can file complaints with them, and they will have like a neutral investigator kind of gather all the facts and interview everybody and make a a decision about whether the Fair Housing Act has been violated. So all those are kinds of things that can put pressure on a landlord and say, hey, this is serious. You might need to do something about this. And there might be potential liability for not doing what you should be doing.
Okay, so again, did we ask a reasonable amount of time? Did you answer that part? Is it 1 month? Is it 4 months? Is it a year?
It's going to be fact specific. I mean, it seems to me if someone has difficulty with their mobility and they made a request and they're just sitting there waiting, it's a problem. But there's no exact science to it. But
There's no limit then.
no, I wouldn't say that. I would say just the opposite. I would say, like,
I'm trying to
you
figure
know,
out.
it's having a negative effect on this
Enough.
person every day that this is happening, and it's been months now.
Okay. All right. I think that wraps that question up. This is Kathy. I've got a different question altogether. It's concerning graffiti on the property that belongs to the landlord, but it was directed at this person and it is actually on their door and inside the fence of their property. She has been waiting, about 2 months now after informing the landlord and the property manager, landlord, whichever came out and actually took a look at it. Still been 2 months and that's never been removed. It's very offensive. And what recourse is there for that? Something like that.
Partly, it depends on what you say when you say it's offensive. If it brought in all these fair housing laws, say the graffiti were targeted in some way based on someone's race or on their sexual orientation or their religion, the landlord would definitely has a responsibility under landlord-tenant laws to. I think it's analogous enough to kind of situation where it's clear there is a landlord responsibility, which is, say, you have two neighbors in an apartment complex, and one of them is harassing the other based on their race.
Mhm.
If the landlord hears about that from the person who's being harassed, they have a responsibility to do something about it, and they can be liable
Mhm.
for not doing anything about it. If it's more simply just graffiti, I hate to put it that way, and it just is unpleasant and not nice to have there. I think that kind of goes back to the landlord-tenant acts as the landlord shall do whatever is necessary to keep the premises in a fit and habitable condition.
Yeah.
That's a broad statement, and I think you can try to fit all sorts of things into it and could potentially do something like this.
Yeah. Okay. In this particular case, it's not a slur against any protected class, as you mentioned. Basically, there's nothing legal that she could do about it per se, other than she can just keep verbally getting after the landlord to get it cleaned up.
Which, yeah, and
Or-
it's foul language too.
Yeah, but that's not protected class. It's just foul language. Yeah. Otherwise, I suppose the other thing, I wonder if she would have rights to take care of it herself. If she wanted to get a can of paint and cover it all up, what would that be?
Oh, that can be a difficult area because typically it goes back to making improvements,
Yeah.
your own repairs to places. There are risks to doing that if it's not done in such a way that the owner is happy about. They might turn around and say, you made it worse by doing this.
Mhm.
And I'm not saying that's a risk, is I guess what I would say. So
Yeah.
that could be tough,
Yeah.
a tough call to make.
Yeah. And I suppose she could also get permission from the landlord, for her to go ahead and do it. And then it would be different. It would be good.
Sure.
Yeah,
Yeah, that's a great suggestion. Yeah.
Yes. Yeah. She could just get it in writing, of course, because then they couldn't come back and accuse her of making a modification without permission. Anyway, thank you.
Thanks, Kathy and Tanya. SJ had her hand up. SJ, you're up.
Thank you. And the only question I had is I get a lot of calls in my role about infestation, bed bug issues. And typically I just tell people that I work with that I believe that a landlord has the duty to treat and remediate any kind of infestations. Is that true? Or what responsibility does the landlord have to address bed bug or mice or shrew or anything like that kind of issues?
Sure. As an advocate of tenants, I would certainly strongly argue that this time I think maybe I did quote it, but this is the part of the Landlord-Tenant Act that talks about that. It says the landlord shall make all repairs and do whatever is necessary to put and keep the premises in a fit and habitable condition. And I'd certainly say that pest control is a big part of that, or was included within that. You'll often find nowadays a lot of leases that explicitly put the cost of extermination or whatever you want to call it on the tenant. Maybe not where it's like the first time we'll pay for it, and then the second time you have to pay for it, things like that. But I would certainly make the argument that clause in a lease would violate this part of the law and is therefore, not enforceable, and that the responsibility is on the landlord. I think another kind of just factual point related to that is that a lot of infestations they don't happen in a unit. The pests move from unit to unit, and they can't be effectively treated by treating one unit. It's really, again, that makes it more the landlord's responsibility to deal with admittedly, what can be a very high cost to dealing with pest issues, I think. So that's my general argument about that. I think the exception to that would be like if there's a tenant who's not actively participating in an ongoing pest control treatment, right? They refuse to let the people in, or they refuse to prepare their unit in the way that's instructed by the pest control company. Then it might arguably put the liability more clearly on the tenant.
SJ, I know you had one more thing you wanted to say, but I want to follow up on that. Does the landlord have the right to enter a tenant's apartment at any time for any reason, or what are the parameters around that?
Yes, landlords have a pretty strong right to enter into the unit, to do inspections, to show the place to prospective tenants or buyers, things like that. It's pretty broad right. The landlord does have to give a 24-hour written notice. That's going to happen. It gets real fuzzy in areas where I'm going to come by sometime tomorrow between 8 a.m. and 8 p.m. But the law doesn't really specifically address that. The law does also say that if it's unreasonable or used for harassment, that it's not appropriate for the landlord to do that.
And SJ, did you have anything else you wanted to say?
Yes, I hope everyone can see the chat conversation, but in case everyone can't, and I just remembered something, a resource that I often give the people that I work with is Alaska Legal Services has a landlord-tenant hotline Monday through Thursday evening from 6 to 8 p.m. You look like you had I don't know, Dan, is that correct?
No, yeah, that's absolutely correct.
Okay.
I guess the only thing I'd add is it's one volunteer attorney per night. So sometimes it can take a while to get through because there's not like a phone bank or something. So just keep it.
And if you wanted that number, you can look at the Alaska. It's a toll-free number. I didn't put that in the chat. But anyway, you can look at Alaska Legal Services website to get that number. Also, some other information I put in the chat is the courts in Alaska have an eviction diversion program. So if a tenant ever has an eviction, please look at that link that I dropped in the chat where you can, I guess it's you and your landlord, have some kind of mediation to hopefully resolve a pending eviction. But please take a look at that link. The other link that I put in the chat is right now there's some basic housing assistance, financial assistance, but it's a lottery system. So please look at that link. It's being managed by Catholic Social Services, the Third Avenue Navigation Center. Please take a look at that link. And if you have an eviction notice, they might be able to help you if you're selected out of this lottery after you complete the entire application online. The next resource I put in the chat, if you are a veteran who is at risk of homelessness or who is experiencing homelessness, there's a toll-free 24-hour, 7-day a week, 365 hotline that any veteran around the nation can call. And that number is 877-424-3838. And I will just do a little bit of disclosure. I work at the VA and my job is to answer this call, to answer the calls that come in through that number. Anyway, so if you need any kind of housing assistance and you're a veteran, please reach out to that number. Thank you.
Thank you, SJ. And thank you, Dan Coons, so much for coming. I am going to ask one last question. I think I know the answer, but it's basically following up on Elizabeth's question about how many references a landlord can require. And it sounds like it's up to the landlord. And I'm curious about the deposit amount. If a landlord said they wanted first and last month's rent and an extra month of rent as the deposit, so essentially 3 months rent as deposit, that would be, could they do that?
No, that would be too much. There is a rule about that. Again, let me make sure just that I'm getting it right. I believe it's double. A landlord may not demand or receive prepaid rent or a security deposit, so they get combined together, however denominated in amount or value in excess of 2 months periodic rent. Yeah.
Okay,
so
that's good to know.
Security deposit last, of course, first month would be you're paying it, so that wouldn't really count. That's not true, just FYI. If the rent, and this is actually now, probably years ago, this was like an exception, but it says this section does not apply to rental units where the rent exceeds $2,000 per month, which now for a multi-bedroom.
If you're renting $2,000 a month, they could ask for a $6,000 deposit.
They could, yeah, because I think it was designed for like people who had like really high rents, but now that's not really that high anymore.
That's not that high.
Yeah.
Wow. It sounds like there is room for the legislature to be involved here. And I am really grateful for you spending some time with us and answering our questions. Just so everyone knows, I will, when I release this as a podcast, I will drop all of the links from the chat into the show notes. So when you access the recording of this meeting, you'll be able to find all of those resources. And again, big thanks to Dan Coons for being here tonight. And thanks everybody for taking the time to ask some questions and learn a little bit more about renters' rights. I have included links to the resources mentioned and to Alaska Legal Services Corporation, which is where our guest Dan Coons works. Thank you to you, our listeners. If you like what you heard, please subscribe, rate, and review us. To contact me, email eastanchoragebookclub@gmail.com. That's eastanchoragebookclub, all one word, @gmail.com.